Good morning and welcome to this morning's Knowledge Bank. Today's webinar will be hosted by Ransford Addo-Quaye. Sorry, I'm not sure if I pronounced your surname correctly, Ransford. Solicitor at Bolt Burdon, and we'll be discussing private sector possession proceedings. If you have any questions throughout the session today, please submit them via the Q&A button at the bottom of your screen, and we will try to get through as many as possible at the end. The webinar is being recorded today and will be available to watch back later this afternoon with a copy of the slides. That is all from me for now. I will now pass you over to Ransford to begin the session.
Morning everyone. Welcome to the webinar on private sector possession proceedings. I'm Ransford Addo-Quaye, a solicitor at Bolt Burdon Solicitors. Here we go. Right. Obviously, we have to begin with the different variations on tenancies, the different types of tenancy that a tenant or occupant may have. You start with licenses, common law tenancies, Rent Act tenancies, which we very rarely see these days. They've been replaced in large part by assured tenancies and assured shorthold tenancies. When looking at your tenancy, the label, you always have to remember that that is unimportant. It doesn't go by the name of the agreement, it goes by the form of the agreement, what's in the agreement itself. I've had agreements come across my desk labeled guaranteed rent agreement when they're actually leases. I've had leases that are actually licenses. It's important to look at the terms of the agreement in order to determine where you go from there. Agreement for use of property without exclusive possession. Now these are licenses, that's a standard license. A grant of exclusive possession for a term at a rent will almost always mean that the occupant is a tenant. Whatever you may think, obviously tenant, occupier, it affects what method you have to use to evict said occupants. So it's an important distinction to make. The test is with exclusive possession. It's what things you have to look for: exclusive possession, a term and an agreed rent. If you have all three, you have a tenancy. If you only have the second and third, a term and an agreed rent, it's a license. The next form of tenancy is a common law tenancy. Now this is anything outside of the Rent Act, the Housing Act 88 and the Housing Act 96. There's no security of tenure with these, no rent control, and very limited statutory protection from eviction, disrepair, and unfair trading practices. Landlords will have implied repairing covenants in common law tenancies, and the Consumer Rights Act will step in to void any unfair terms. But that's really the only protection that you get from common law tenancies. That also is quite rare these days. These tenancies, common law tenancies, are quite rare these days. Now, the different variations, the Rent Act. This is something that is still, they're still around. They're very, very uncommon these days. Almost all private tenancies prior to January 89 will be Rent Act tenancies. That's very few, as you know, things come and go, tenancies, occupancies change again and again. These tenancies are replaced quite often by assured and assured shorthold tenancies. But in order to have a Rent Act tenancy, there must be a tenancy of a dwelling house in a separate dwelling, i.e. not living or sharing commodities, utilities with the landlord. The tenant must be an individual and must be in occupation of the property. Now, Rent Act tenancies come with things like security of tenure, succession rights once the original tenant passes away, or if they were to pass away. And Rent Act tenancies have the option of having a fair rent registered for that property and for that rent to be capped. It's something that's very tenant oriented, and that's mostly the reason why you just don't find them these days. It has to be a tenancy, not a license, like we've talked about, dwelling house, including flats and bedsits. Security of tenure, like we've just discussed. Statutory tenancies arise on expiry of the contractual fixed terms. They operate on the same terms as the tenancy, and they provide security to whichever occupant is in the property, even after the original occupant's death. And so landlords can only really gain possession either at the end of the fixed term, when the tenant decides to leave, whoever's in there at the time, or if they get an order from court. The difficulty with Rent Act tenancies is that you will only get a possession order, an order from court, if one, the court, if you can show the court that you've already set up alternative housing for this tenant that you're trying to evict, and two, if the court feels that it's reasonable and equitable for you to evict that tenant. It's very, very difficult to evict Rent Act tenants, and that's why you just don't see them any longer. Succession. Now, Rent Act tenancies, they allow for two steps in succession, if you like. So the first is where the original tenant dies, a spouse or civil partner or cohabitee is allowed to, same-sex cohabitee, is allowed to inherit the tenancy upon the death of the original tenant. And if there is no same-sex partner, if there is no cohabitee or spouse, then a family member that was living with them for 2 years prior to the original tenant's death can succeed the original tenant. Failing that, or once the first successor has then died, a family member of the original tenant, somebody who is a family member of the original tenant and the first successor, can then succeed the tenancy. So a landlord on a Rent Act tenancy can be waiting for the first tenant to pass away and for the successor to pass away before then trying to evict the third, if you like, in line to that property. Now, the Rent Act tenancies were the most common form before 1988, but then comes the Housing Act 1988, which actually came into force the following year, much more favorable to landlords than the Rent Act, and now covers the overwhelming majority of residential tenancies in England and Wales. Introduced the assured tenancy and the assured shorthold tenancy, did away with security of tenure, with succession, with all of these quite large barriers and hurdles that landlords had to overcome. The assured tenancy and assured shorthold tenancy. Now, the conditions for the assured tenancy are that there's rent payable to a private landlord. The landlord must live outside of the premises. If the landlord lives with you, then you're more likely an excluded occupier rather than a tenant. The tenancy must be created between 89 and 97. Now that is for the default classification as an assured tenant. Obviously, there are tenancies either side of this where landlords maybe have served notice saying that we want this to be an assured tenancy. That's fine. but by default, anything between January 89 and February 97 will count as an assured tenancy. And the next point, where the landlord does not serve a notice stating the tenancy must be an AST and it falls within that time, then it's an assured tenancy like we've just discussed. Post February 97, almost all tenancies are assured short hold tenancies, unless, like we say, a notice was served specifically stating that the tenancy is to be an assured tenancy. The landlord serves written notice before, like we've just discussed, and the tenant previously had an assured tenancy in the same accommodation with the landlord. That's actually quite rare to have. It's not something that happens these days. Now, an assured short hold tenancy is basically an assured tenancy. It's almost the same as an assured tenancy. The difference being that with an assured tenancy, you can only, well, the difference between an assured tenancy and the Rent Act tenancy is that the Rent Act, it's almost impossible to evict the tenant. The assured tenancy, you can evict them using the Section 8 notice or the fault notices or a notice to quit. Yep. This brings in avenues for the landlord to say something has gone wrong in the tenancy, the tenant has made some mistake, and I want to end this agreement. The difference between that and the assured short hold tenancy is that the assured short hold has use of the Section 21, which is a no fault procedure. So the assured short hold, fault, the assured tenancy, fault, the assured short hold, no fault tenancies. Interestingly, you can actually use both for the assured short hold tenancy, the Section 8 and the Section 21. The assured tenancy is just the Section 8 and a notice to quit, and that's sort of the interplay between those two. Termination by the tenant. This, again, is quite rare unless the tenant has some exceptional circumstances causing them to need to leave. The first is the break option during the fixed term. There will often be, you have to go by the different agreements, read through the ASTs quite carefully. There will be break options available to the landlord and to the tenant in most cases. The tenant can use this to vacate, end their tenancy early, and that will be the end of that. Or they can wait until the end of the tenancy and vacate. Now, they need to do so promptly, put that in there, because if they don't, if the tenant at the end of the tenancy does not leave almost immediately on expiry, then what happens is a statutory periodic tenancy is created. This is it's a statutory tenancy that runs on the same terms as the fixed tenancy that you thought you had just ended or that has just finished. Another option for the tenant to end their tenancy is a surrender, which is an agreement with the landlord. An agreement between the landlord and tenant to end the tenancy early it's restricted by Section 5.5 of the Housing Act 88, which basically states that this agreement cannot come before the tenancy is entered into. What's the difference between that and a break option? So basically, that the break option is it's lying in wait. It's not something that ever needs to be used or can just go through the entire agreement without activating the break option, whereas the surrender, if you do so before the tenancy, you can't agree before you enter into a contract that the contract will end prematurely. It's just not something that follows, that makes sense. Or the notice to quit, which is the last option that the tenant has to end the tenancy ahead of time. It sort of loops back around to the break option, because when activating the break option, that's when the tenant will be using the notice to quit. Now, termination by the landlord. Two main routes under the Housing Act. sections 8 and 21. With an assured tenancy, as we've discussed, only the section 8 can be used, whereas with an AST, you can terminate using either the section 21 or the section 8. The things that you'll need to consider when deciding, whether to do one, the other, or both is things like, are you within the fixed term? So for argument's sake, or for example, you've got a 3-year tenancy or a 2-year tenancy, and 10 months in, the landlord and tenant relationship has broken down. You can't use the section 21 notice in that case, because you're still within the fixed term. Section 21 notice is now a 2-month notice period that will expire before the fixed term ends, and therefore you can't use it in this case. But if there was some fault that you could prove on the part of the tenant, then you could use the section 8 notice. Urgency for possession. Do you need to get this done now? Does it need to be, perhaps the break clause is time sensitive? And in which case you could either serve a section 8, get it done now, end the tenancy or notice to quit, or you could serve the section 21, which, like we've said, has a 2-month notice period. It's just things that you have to consider, the back and forth. And then the costs. The section 21, being the no fault eviction, is dealt with almost exclusively on paperwork, which means there's no need for a hearing to be called, a court hearing, which saves time and cost for everyone involved, especially for the landlord. Both notices have their pros and cons. For example, the section 21 has preconditions that need to be met before it can even be served. Quite stringent preconditions at that. Balance against this, some of the section 8 grounds are only available during the fixed term. So as soon as that ends, once you're in a periodic, you then can't use that notice. So it's really a balancing act that the landlord has to go through when determining how they're going to bring these tenancies to a close. Now we'll start with the section 8 notice. The grounds are set out in Schedule 2 of the Housing Act 1988. They're split into mandatory and discretionary grounds. Now, the mandatory grounds, if you can prove a mandatory ground, then the court, the judge, must make an order for possession in favor of the landlord. Where a discretionary ground is used, the court doesn't need to make that possession order unless they feel it's reasonable to do so. If you go in with just a discretionary ground, it's an unsafe notice, basically. It's an unsafe claim against the tenant. And so people are encouraged to use a combination of mandatory and discretionary grounds. The mandatory grounds are on screen now. I'll let you go through those in your own time, but what we need to be aware of here is ground 8, serious rent arrears. This is the most common of the mandatory grounds. It's quite obvious. We've just come out of a quite extensive lockdown period where many people weren't working or on reduced pay. Serious rent arrears were built up and down the country, and we'll be coming into a lot of those matters. We're coming into them now, actually. And so that's the most common, what you'll most commonly see with the mandatory grounds, section 8. We say ground 8 most frequently combined with discretionary grounds, as we've discussed, 10 and 11, 10 being that there's some arrears owing the date of the notice, and 11 being that there's been persistent delay in paying rent. The landlord needs to show arrears at both the date of the notice and date of the hearing. This is very important. You could serve notice with somebody being in, say, I don't know, 4 or 5 months of arrears. And then a week before the hearing, all of those arrears are cleared. If you've only used the mandatory ground 8, then you'll no longer have grounds for possession going into the hearing. You'll be on quite shaky ground. Whereas if you've combined them with grounds 10 and 11, then at least you have the opportunity to go in and show, you point to rent schedules, etc., point to previous behavior of the landlord, of the tenant in not paying rent, in paying rent late, and that will give you some chance of swaying a judge. And quite often you need every every advantage that you can get. Landlord must show arrears both notice. The way they can do this is by giving oral evidence. That's turning up on the day, either the landlord or a registered agent turning up on the day and giving oral evidence as to the amount of arrears, how the arrears have come to be at the level that they are. By submitting a rent schedule, rent schedule is termed as something that the landlord uses in their business. Now, most social or private sector landlords won't be letting as a business, so any sort of written schedule, any diary kept, will be helpful in that regard. Or an admission from the tenant can also satisfy ground 8. That is quite clearly unlikely to happen. And then the court must be satisfied as to the level of arrears. The discretionary grounds are here. 10 and 11 we've discussed. 12 is just some other breach of the tenancy. I will leave those on the slides for you to go through in your own time. Now, the section 21 procedure, it's faster. We discussed that. Where the grounds are set out and established, the court must make a possession order. Preconditions to service, although not all of them apply before 2015. And the notice itself cannot be served within the first 4 months of any new tenancy. Must be in writing using a prescribed form. Now that form has changed over the years. Currently it's the form 6A and can be downloaded from the gov.uk website. Form 6A applies to both sections 22.1, fixed term tenancies, and 22.4, which are periodic tenancies. Currently, the notice period is 2 months. You serve the notice, it can't expire before 2 months, and then possession proceedings must begin within the following 4 months, or else the notice is invalid and can no longer be used. The notice needs to be served by the landlord or by joint landlords, and can also be served by the landlord's agents as well. Now, when a section 21 cannot be served, tenancy deposits, if your deposit has not been protected, then you won't be able to use the section 21 procedure. It will make your notice invalid. You have 30 days to protect any tenancy deposit you take, 28 days to give the tenant any prescribed information that is mandated by your TDS scheme. Otherwise, you leave yourself open to a strict liability offence under the Housing Act. Now, this is important because if the tenancy is not protected, sorry, the deposit is not protected, even once the tenancy ends, the landlord is at risk of the tenant coming back and issuing a money claim against them, essentially for up to 3 times the deposit. Like I say, it's a strict liability offence. And so the landlord doesn't want that hanging over them. Strict liability on the part of the landlord, meaning that even if it was the agent's fault, it's the landlord who takes the fall. And so agents won't want landlords hanging over them either. Next is the property license. In order to serve a valid Section 21, there needs to be a valid property license in place. If the relevant local council requires such a license, be it an HMO or a selective license, it is enough to apply for that license and have notification from the local council that your license is being considered or has been accepted or has been received before you can serve the Section 21 notice. It doesn't actually have to have come back with the full license. The EPC and gas safety certificate, these were brought in by the Deregulation Act 2015. Any tenancies created after 1st of October 2015, now that's new tenancies. So if your tenancy was created before that date and then renewed on a periodic tenancy after that date, you're not caught by this. But anything after October 2015, you need to have served an energy performance certificate and a gas safety certificate. They need to be current as at the date of the Section 21 notice. So if you serve them initially, they've expired, you'll need to get new ones before your Section 21 can be valid. Currently, they don't need to have been served before the tenancy began, just need to have been served before the notice was served. More information on that. I'll leave that for you to mull over in your own time. But the case of Minister and Hathaway, I will highlight because that speaks to something that we've just gone over, in that the energy performance certificate and gas safety record requirements do not apply to tenancies granted before 1st of October 2015. And then one of the last points is the how to rent booklet. This can be served in hard copy or email. There's really no excuse for not serving this. You only need to serve it once. Every time they update it, you don't need to bother yourself with that. And then the Tenant Fees Act, there's a long list of offences under the Tenant Fees Act. Essentially, it's the landlord and their agents not requiring any payments other than rent or reasonable renewal costs from the tenant. There will be a list of offences in the Tenant Fees Act that if the landlord or the agent has breached any one of them, will invalidate the notice. Now, retaliatory evictions, these essentially boil down to when the tenant has complained of any disrepair. The court look at the response by the landlord and their agents when this came in, and the rules around retaliatory evictions are basically to stop rogue landlords, essentially, who will have tenants complaining of genuine disrepair, genuine problems affecting their lives at these properties, and will simply just evict tenants so they don't have to deal with this. Local councils are able to serve remedial notices or improvement notices on landlords, and if this notice is served, you cannot serve a Section 21 within 6 months of that, or within 6 months of that notice being squashed or revoked. This is something we've gone over already. The tenant does not leave the property within the time the notice expires. The landlord must issue proceedings, cannot do so after 6 months within when the notice was given. Now, the proceedings for Section 21 can be accelerated or they can be on a standard basis. The accelerated is what we discussed at the beginning of this. It's just based on the paperwork, whereas the standard possession proceedings involve a hearing and getting together witness statements. During COVID, they involved review hearings, and it was just a much more drawn out process. Because the accelerated is done on the paperwork, it's much more condensed and streamlined. If you tick all of the boxes before you begin proceedings, then the court must give you a possession order, and that should be that. The possession order, if granted, can be outright, giving the tenant 14 days to leave, or it can be postponed, anything up to 6 further weeks for the tenant to vacate. Depends on what representations the tenant is able to make. The accelerated procedure is governed by Part 2 of CPR 55. Can be brought in any county court hearing centre, and is carried out by filing or is initiated by filing Form N5B. This is one form that encapsulates the claim, the landlord's claim, and particulars. We'll go through every single characteristic of the tenancy, and just a summary of events. And then the standard procedure operates a lot like the Section 8 court procedure, where forms N5 and N119 are filled out. These are the claim form and particulars of claim. Termination by the landlords on a notice to quit. These are most often 1 month notices. They're unilateral actions, doesn't depend on acceptance by the tenant. Once you send it out, that is the end of the tenancy. Obviously, in most cases, you will need, if it's within the fixed term, then you will need a break option or a break notice to serve a notice to quit to bring things to an end. If it's outside of it, then obviously that's a different scenario. Notices to quit are quite useful where there is no written tenancy, because if there isn't a written agreement, then obviously you can't use the first 2 notices we've discussed, the Section 8 and the Section 21. A notice to quit should always be in writing. It's not mandatory, but should always be, as a matter of practice, in writing. And where it's given towards a dwelling should be in writing in any case. There's no set form of notice to quit, but there is set information that needs to be in the notice or at the end of the notice, and that's found in Section 5 of the Protection from Eviction Act 1977. This prescribed information must be in all notices to quit. Now, COVID hit and the country went into lockdown in March 2020. Following this, Practice Direction 55C was introduced. This affected all possession proceedings brought under CPR 55, and all possession proceedings currently in court were stayed from March 2020 to September 2020. Towards the end of this day, so nothing is happening in this time period. Towards the end of this day, the overall arrangements for possession proceedings in England and Wales is introduced, and brings in new rules for, okay, once we open up these proceedings, once we open this court procedure back up, how are things going to run? Because obviously everybody that's been trying to get somebody evicted or trying to protect their home, etc., everything has stalled. So there's going to be a massive backlog. So this overall arrangement was brought in to try and ease the flow, sort of like a roundabout, just helping to maintain the flow of traffic. It was brought in September 2020, and under the new rules, possession procedures would take different routes depending on when each case was started. The stayed claims and anything brought in after 3rd of August 2020 would now be listed for a review hearing. Now, the purpose of the review hearing was for the court to have an opportunity to see whether the paperwork was all in order. If the paperwork isn't in order, it's something that the court doesn't have to deal with. They put it to one side, or they write back to you. Or if you're lucky as a landlord or a claimant, they'll write back to you and tell you what needs doing. If you're unlucky, they'll just dismiss your claim. That's the way it was run. In any case, we were resigned to help the court in identifying issues which were ready to be heard. If they were ready, then the issue would be moved on to a substantive hearing. And for these review hearings, it was basically just a judge alone sat in court looking over all of the paperwork. Now, this paperwork was an extra step, an extra bundle that the claimants needed to prepare and send into court, send into the defendants, the tenants as well. It was quite burdensome on a lot of landlords who had already paid fees to get tenants evicted or to try and recover their properties, and now they're needing to pay for an entirely separate section of work, which couldn't have been discussed because this was entirely new at the time. These review hearings were to last until November 2021. The overall arrangements, so these new rules, were withdrawn on the 1st of November, but the review hearings were still in place until the end of November last year. And then from the 1st of December onwards, the courts were once again listing claims for substantive hearings within 8 weeks. So the Practice Direction 55C comes in, all possession proceedings are paused. Then once that opens back up, the overall arrangements change the way everything runs, bring in the review hearings, which were made to or designed to speed everything up. In reality, they slowed everything down. And then from 1st of December last year, the sort of possession procedure went back to normal, or as normal as you could find post lockdown, post-COVID, post-lockdown. In the interim period, some of the rules that we discussed earlier for claims started on or after the 3rd of August, a reactivation notice was required. Now, during the stay or during the lull, the period when nothing was happening, all claims were stayed. And if your claim came after this date, then you need to serve a reactivation notice in order to have the claim relisted. Failure to do so just meant that your claim would be stayed indefinitely. So your claim wouldn't be dismissed. It would just lie there and not move. If the court receives a reactivation notice, then it will relist for a deadline. It's just basically the court's way of trying to deal with backlog. Where a reactivation notice is not filed, the court would not list, relist, hear, or hear the claim, or refer it to a judge. The consequence was that the matter would be stayed until such time as a successful application was made to lift the stay. So now you're in a position where you're having to apply to lift a stay, a mandatory stay. It's not any fault of the claimants, not any fault of the landlords, but COVID, it was going to come down on either the landlords or the tenant. It came down on the landlords. If your claim was started before the 3rd of August, then there was no need for a reactivation notice. It's just the court's way of dealing with the longest standing claims first. But you did need to serve on the defendant within 14 days prior to the hearing a notice setting out what knowledge you have or had of the effect of the coronavirus pandemic on them and their defendants. Bring 2 notices to the hearing. There were also, in addition to the stays at court of all possession proceedings, there were bans on evictions, wholesale bans on evictions, on bailiffs executing writs of possession, warrants of possession and restitution, or delivering any notices until the 31st of May 2021. and for our colleagues in Wales until the 30th of June 2021. Government guidance states that bailiffs in England were asked not to carry out evictions if they were made aware that anyone in the property has coronavirus symptoms or is self-isolating. That guidance still continues today. So even though everything has opened back up in the world of possession proceedings, if the bailiffs get word that the tenants are suffering coronavirus symptoms, they just won't carry out your eviction. If you're using county court bailiffs, you're then having to reapply because your date will come and go, and then you're waiting 6 to 8 weeks for another appointment. It's just a symptom of the world we live in now, unfortunately. The Coronavirus Act came in 2020, introducing new notice periods between March 2020 and September last year. These are important to remember because some of these are still governing the notices that are being dealt with now. The changes that were brought in are now largely gone, but as we say, some of these notices are still being litigated over now. So let's have a look at some of the dates that were changed. Right, from anything from the 26th of March to the 28th of August 2020, 3 months notice were required. Now, if you consider that Section 21 notices are 2-month notices, minimum 2 months, and Section 8 on ground 8, which is extreme rent arrears, are 2-week notices, this immediately came in and said, scrap all of that. We now need to serve notices that last for a minimum of 3 months. It's just the court kicking the can down the line. From the 29th of August to the 31st of May, notice periods went up to 6 months. And then from the 1st of June to the 30th of September, they came back down to 4 months. And then post 30th September 2021, all notice periods went back to normal. There were exceptions for these. For instance, on Section 8, let's say you served your Section 8 between the 1st of June and the 30th of September last year. If your tenant was in at least 4 months of arrears, then you wouldn't have to serve a 4-month notice, you could serve a 4-week notice. There were specific exceptions that applied here and there, and it's important to be aware of those because we have seen some of these notices come across our desks where landlords or their agents will say, look, we've served notice, we just need you to issue the proceedings. We say, okay, let's have a look at the notice. And some of these notices are from these times, but don't have the correct notice periods in them. And it's just something, if the solicitor's role is to problem solve, then obviously you want to come to us with as few problems as you possibly can, limit the time involved and limit the cost to yourselves. Now, in terms of the future, the rules set out for cases on or after 3rd of August will continue to have effect. That is the claimant or the landlord having to serve a notice which doesn't have a form along with possession proceedings to say what effect the coronavirus pandemic has had on defendants, whether they're aware of that or not. That still is in place until June this year, unfortunately. So government guidance, there are pleas to landlords. You can actually find these on the government website. Just go through this. In light of the many difficulties caused by the COVID-19 pandemic, We urge everyone to show compassion and exercise flexibility as far as possible. We therefore encourage you only to seek possession where you have grounds to do so, having tried to resolve any issues with your tenant first. We strongly recommend that you only seek possession through a Section 21 notice with grounds if there are no other alternatives to doing so. It's basically a plea from the government and from judges to keep possession proceedings to a minimum. Unfortunately, there isn't much scope to do so. Things were on hold for a very long time, with the cost of living going up and up and up. With residential tenancies, there's bound to be a lot more of these possession proceedings being enacted or being continued where they maybe once were stayed. And it's also often the case, it's unavoidable that once we have the notice, or once a tenant receives the notice, that is more often than not the end of the landlord and tenant relationship. And so it's a difficult one. It's a difficult set of waters to navigate. There is a proposed third route to terminate ASTs. That's in addition to Section 8s and Section 21s. These would come in for recovery of possession of abandoned premises, but a date is yet to be confirmed. These are still discussions ongoing. Mediation services launched by the TDS and the PRS. These unfortunately don't do a lot for possession proceedings themselves, but they do help landlords and tenants to reach agreements, hopefully avoiding possession proceedings altogether. The PRS is the Property Redress Scheme. And the government is yet to publish their rental reform white paper, which is a precursor to the Renters Reform Bill, which is part of the Tory manifesto in 2020. This just is ongoing proposals to scrap the Section 21 procedure. You may have heard this. This has been in the works for quite some time. We'll see whether it goes through. As of right now, the Section 21 procedure is very much alive and kicking. And that brings us to the end. We've gone through, sort of whizzed through all of those matters. There is quite a substantial amount of information on the slides. I'm happy to answer any questions that we have now. I'm going to go through. There's a question from me. Does the How to Rent booklet need to be served on the same tenants renewing their AST or only on new lettings? Yes, the How to Rent booklet will need to be served on new lettings, absolutely. When renewing the ASTs, it won't need new How to Rent booklets, but it's always prudent to reserve. Like I say, it can be done by email or in hard copy. So I would always advise, can't give legal advice without knowing the ins and outs of your matter, of course, but it would always be the preferred option to reserve. Just give it a minute in case any other questions come through, but if not, then thanks for being online with us.
Hi, Ransford. I'll give it a minute in case there's any more questions, but that's normally a good sign. I think you've answered everything that could have been answered in the session. No more questions, I don't think. Okay, I think we can leave it there then if there's no more questions coming in. Thank you so much for your time today, Ransford, and thank you everyone else for joining us. We will have another session with Bolt Burdon on Thursday, which will be covering the commercial rent coronavirus bill. If you'd like to register for that, please visit the News on the Block website. As I mentioned, today's session has been recorded, so I'll be sending out that to everyone this afternoon with a copy of the slides. And yeah, other than that, thank you so much for joining us, and I will see you on Thursday. Thanks, Ransford.
Thank you. Bye-bye.
Bye.